Pre-packaged insolvency resolution process of MSMEs. The Indian Express examines the pre-packaged insolvency resolution process, how it differs from corporate insolvency resolution process, and key hurdles that the new mechanism may face in gaining traction. The Insolvency and Bankruptcy Code Amendment Bill 2021 that was passed in Lok Sabha on Monday replaces the IBC Amendment Ordinance 2021 promulgated in April, which introduced pre-PACs as an insolvency resolution mechanism for micro, small and medium enterprises. We examine the pre-packaged insolvency resolution process, how it differs from the corporate insolvency resolution process, and key hurdles that the new mechanism may face in gaining traction. What are pre-PACs? A pre-PAC entails the resolution of the debt of a distressed company through a direct agreement between secured creditors and the existing owners or outside investors instead of a public bidding process. This system of insolvency proceeding has become an increasingly popular mechanism for insolvency resolution in the UK and Europe over the past decade. Under the pre-PAC system, financial creditors will agree to terms with the promoters or a potential investor and seek approval of the resolution plan from the National Company Law Tribunal. The approval of a minimum of 66% of financial creditors that are unrelated to the corporate debtor would be required before a resolution plan is submitted to the NCLT. Further, NCLTs are also required to either accept or reject any application for a pre-PAC insolvency proceedings before considering a petition for a CIRP. So, what are the benefits of pre-PACs over the corporate insolvency resolution process? One of the key criticisms of the CIRP has been time taken for resolution. At the end March 2021, 79% of the 1723 ongoing insolvency resolution proceedings had crossed the 270-day threshold. One of the key reasons behind delays in CIRPs are prolonged litigations by erstwhile promoters and potential bidders. The pre-PAC, in contrast, is limited to a maximum of 120 days with only 90 days available to stakeholders to bring a resolution plan for approval before the NCLT. Another key difference between pre-PACs and CIRP is that the existing management retains control in the case of a pre-PAC while a resolution professional takes control of the debtor as a representative of financial creditors in the case of CIRP. Experts note that this allows for minimal disruption of operations relative to a CIRP. What is the key aim behind the introduction of the pre-PAC? According to sources aware of development, pre-PACs are largely aimed at providing MSMEs with an opportunity to restructure their liabilities and start with a clean slate while still providing adequate protection so that the system is not misused by firms to avoid making payments to creditors. Currently, only corporate debtors themselves are permitted to initiate a PIRP after obtaining the approval of 66% of their creditors. The pre-PAC mechanism does, however, allow for swift challenge to any resolution plans which provides less than full recovery of dues for operational creditors. Under the swift challenge mechanism, any third party would be permitted to submit a resolution plan for the distressed company, and the original applicant would have to be either match the improved resolution plan or forego the investment. What are some of the challenges in the use of pre-PACs? Experts noted that the timeline for the PIRP may be difficult to meet for lenders and distressed firms, and the forensic audits were particularly important in cases where the control of the firm remains with the same management. Ordinarily, where the haircuts are involved, forensic transaction audit becomes imperative and a negative report becomes a roadblock in resolution involving the same management, said Anup Rawat, partner insolvency and bankruptcy at Sardul Amarchand Mangaldas and Co. Rawat also said that if a firm restructures its outstanding debt through a PIRP with the existing management retaining control, the NPA status of the company's account with lenders may not be automatically under RBI guidelines. In order to motivate resolution under the PIRP, the RBI guidelines on account status may be aligned with the objective of IBC, and the lenders may be given a benefit of account upgradation upon resolution. There is a need for the IBBI and RBI to find a middle ground on these regulations to make the PIRP more attractive, he said. Experts also noted that the debtor in possession model may pose a challenge to the switch challenge option available to lenders, as the existing management may create hurdles for any outside investor seeking information to potentially invest in the company. Under the CIRP, a resolution professional in charge of running the company and providing information to potential investors. What's next? Experts have noted that the pre-pack mechanism is an effective mechanism to arrive at a quick resolution for distressed companies, and the regime should be rolled out to all corporations over time as legal issues under the mechanism are settled through case law. Thank you.